And hopefully I got answers to all your questions. Let's go to...
Yes, hi, Brad.
Hi, Ann. How are you?
I'm good. How are you?
Good. What's going on?
I spoke with you I called last week during the show, and I just went into clarification again. You mentioned that before, if you have a offense like before 5 years upon entry, then it's a deportable crime.
Were you the person who called about that you were the victim of domestic violence? You were concerned with your husband?
No.
Oh, that
I
was somebody else.
The one who called last week about the baby and having a affair while I was in the marriage and had a baby.
Okay.
That was me. But then I had another question regarding...
So tell me your question again about getting arrested within the first 5 years?
Yes. The 5 year prior to entry. Is that... When I had my green card, nobody mentioned that. I don't remember ever being asked that. I had that offense in 2008, and then 2009 I got married, then had my green card in 2010.
When did you come to the United States?
2005.
Okay, so, and what was the arrest in 2009?
It was no arrest. It was a petty theft.
Okay, so a petty theft is generally a petty offense. So so there's an exception to that.
So they don't bring that back during the interview?
Well, they bring it up as an interview, but as a petty offense, you would still be entitled to a green card. What you can have is a crime of moral turpitude committed within the first 5 years of entry as a deportable and inadmissible. It is
deportable?
Yeah.
So you saying they're going to mention it?
No, what I'm saying is that you have a petty offense that is not inadmissible, but you certainly have to mention it when you get your green card. If you were arrested and immigration didn't know about an arrest, that's a problem, and I would suggest you have a consultation with us. Otherwise, don't worry about it. Then don't worry about it. If there's no arrest, there's no arrest.
Yeah, there was no arrest. Okay, thank you. Appreciate it.
Then I'm not sure what happened there, but okay. Let's go to Bianca in Naples, Florida.
Hi, thanks for taking my call.
How are you?
I have a question. So I have 2 kids under the age of 18 that overstayed their time, and I wanted to apply for their green card. Would that be possible?
What is your status?
I am actually doing my green card interview next month on the 20th.
Who's sponsoring you?
My husband. He's a permanent resident.
He's a permanent resident. Okay, and why has he not filed for your children? Because they're overstays already?
They overstayed already. We kind of mixed it up because we did it ourselves. We thought we had to do me first and then them.
So they overstayed. I understand. How old are they?
Yeah, 15 and 6.
Okay. And where is the biological father of these children?
Back in both of our home countries.
Which is?
The Bahamas.
The Bahamas. Does he have a relationship with the children?
They do, yeah.
They do, okay. All right, so because he has a relationship with the children, we're not going to do a SIJ, Special Immigrant Juvenile. What your husband should do is file I-130 visa petitions for your children immediately.
When we filed the I-130, we had them down on it because we read that because he's a permanent resident, we don't need to do separate I-130s.
Right.
Only if he was a citizen.
You want to do it faster, file I-130s for the kids now. Because other than that, they're included on your case. They've overstayed their time. So what would have to happen is after you get your green card, which who knows when that will be, you then have to file what's called an I-824 application to transfer your approved I-130 from the local office in Florida to the National Visa Center so that the children can follow to join you in the Bahamas. And they would have to go back to the Bahamas and then return. But as long as they're under 18, it's perfectly safe and perfectly fine. The problem becomes an I-824 takes as long as an I-130. So just file the I-130 now. It will be faster. And you have to pay filing fees for the I-824 anyway.
Okay, so don't just go ahead and file a I-485 for them.
No, because they're not eligible because they've overstayed their time. You would have to file I-130s for them, and they would have to go back to the Bahamas to pick up their green cards. before they turn 18 years old. Now, if your husband becomes a citizen anytime between now and the time the children turn 18, then you can do an adjustment.
Okay, so we can probably just wait until next year. He'll be eligible to do his citizenship.
I would still file I-130s because there's no guarantee he becomes a citizen.
Okay, when I go on my interview, because I have my green card interview next month as well, do I mention all of this to them?
If they ask.
Okay. Okay, thank you.
You're welcome. Good luck. Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.